I like it when judges Emma ruling na lawyers atre wo mo adwen e so say judge no obenten asem a wo kan ye say ni dia oye no judge no wan ye ni ye and all that eya na mepe sorry eya na mepe sa de ne pa unim say asem we si a ende yebo electoral commission echi yebo ne chi ne MPP4 you say omo akwa redeclare 7 seats amomo ho no unim say sa de ni na no asem we si ni na ye kan sansam ni na sa nyama ni na no unim say Ghana for judge a wo ma ruling e wo case no ase obi an person be kan judge no ne ho asem ase asem na ekokoto judge ni nanim no enye no ruling e na judge no wo de ba yo NDC for ene de asem call court electoral commission enya representative MPP4 any representative ewo oho obi anfa counter evidence bi amba ma meto judge n'animu anka ntre judge ne say I mean MPP4 betumi anyom representative and all that but NDC4 no de omo asem aba obi anfa evidence amba meto judge n'animu anka ntre judge ne say NDC4 nsem omo ka no entro say ni and so for the judge to give such a ruling to empower the electoral commission to come and do what they did no e was a Ghana for a kasa a tre judge nso but as obia yekum and a yebo electoral commission no echi there is a private legal practitioner bia friend of Kwame Boafo Ekufu or the nsema ba betuja na sema wa work can say judge ni ruling na wo maaye no nyansa nim di ntia no work say judge ni ruling na wo maaye no nyansa nim yen konsem ni mu na tiase I say a private legal practitioner, Kwame Boafo Ekufu, has criticized the decision of the High Court in Accra, ordering the Electoral Commission of Ghana to go ahead with recollating and redeclaring of results of 5 constituencies where NDC parliamentary candidates had earlier been declared winners. In a write-up cited by Ghana Web, lawyer Boafo Ekufu pointed out a number of issues with the court's order for the commission to recollate and redeclare the parliamentary election results of the 5 constituencies. He indicated that the commission's claim that its officers were forced to declare the initial winners was not proven before the court made its decision, which he indicated was unfortunate. And I want people to understand. Asemwa Ekoso, Electoral Commission for reason in tia say NDC seat ya ye declare no yembongu ne say omo say ye force omo officers no ema officers no omo declare seat no ema NDC sebe wo a wotie mi ene me a make say nyansa ketua eda ye trim ebia wonu minim ba me no de metumi akan say nyansa ketua eda mi trim ene say oh okay Electoral Commission say ye force Omonkrofo emomu declare my NDC. No problem. Electoral Commission waba court. Brabe tre me evidence e tre say indeed ye for say won crofo. Tre video mpo, tre infoni, tre bibi. Judge ne say dabi. Electoral Commission anfa evidence biamba, just word of mouth. Our ba court ho. Eba be kan ye. Say oh, ye for say men crofo no momu declare ema NDC. Judge name bisa say oh evidence wo hen. Ma mention evidence na e tre say indeed ye for say won crofo. Judge name tie. Electoral Commission kan ya na judge nka say oh say ye for say won crofo there and the yenkonko. Do you know how dangerous it is? So now all it takes, okay, for people like Ebia KT Hammond no and all the other MPP people are lose seats in all the constituencies. No, all it has to take, okay, is for them to organize themselves to go to court and go and tell the judge say results now you declare you know you foresee and crow for the judge is not supposed to ask for any evidence and no one say and yeah monko kind for fro you call say you kind for fro so no abana shase numbers necessary. Do we understand the seriousness of what we are talking about? How serious saadie we able to me see e wo man we mu. Inti eno na lawyer ba kon wa sorry said abi. Judge na dia wo ye na nye. Odie na ka obema ruling mpo a. Bisa na electoral commission infa evidence mbra. Ni ehu ne say at least when we electoral commission for evidence e tre say because how can you go to court and say you are forcing me crop for one for evidence bi amba na judge rule am. What be that? No evidence. But you see, no one is even talking about the judge. But you can. Judge ni ruling na wode buy no. And then ababe cause major problem in there. And I am happy that it is one of omwa womon crop for our lawyer and na ekasa. I say it is my understanding that an EC officer spoke to duress as the basis for making a declaration in favor of a candidate. The side in whose favor the declaration was made denies his factual allegation. In such a circumstance, there is a clear case of dispute on the facts or contested evidence for that matter. EC ni kasi force no. NDC the evidence about video about the postia or more trese. Isi ni na wasi ye force ni video ni. O declare no, obi an force no, no sre. Force ben. Inti asem na ba beto wo judge ni mu a. Asem ba can say okay, we asem it is your word against we isi evidence I see ye force no fabra. NDC unso trese one force no unso fa evidence bra na menhwe. Judge mbisa. We rule am isi. Or say the basic law teaches that in contested matters, the law does not admit of judicial review remedies, save in jurisdictional matters where evidence will be laid on a collateral fact. Under the circumstances, the grant of an application for judicial review in an election dispute where allegations of duress are being contested is a flawed position, he wrote. The lawyer also indicated that the parties in whose favor the declaration was made should have been given the chance to defend themselves, but this did not happen. Just like 2020 election petition, Senior Jimensa call Supreme Court was a wababe account ebabe defende in some way course no 1 year no. That's exactly what happened in court way. Wama isi na sem kraye kan ama no. Wama ankoso. I said the parties in whose favor the declaration was made should have been given the chance to defend themselves, but this does not happen. Inti isi na ono ye declare man no. Ye rule ama no. Ono kra no. Yaman ankasa ewo court. Yaman wan training se mumpo. Na no court na ye koye no court papa ben ye koye. NDC ena woni EC enya asem. Ena NDC e de akwa akoto EC enim se e de akwa akoto court enim se EC no see me nso me see wentie EC na asem wa wanje evidence utie NDC asem a wo se yenko de EC ne pani emfama no he e wo krom ha. Also, the allegation of duress by the EC officer is one that has hints of criminality, and thus the court will reach a decision on same on a slight scale above the balance of probabilities in civil proceedings. It is for the EC, which alleges duress, to come before the court to raise the issue, and not the other way around. In the next place, Nekrano. Nanka obi edi asem ne beko court electoral commission ne wo say de ko Ghana mra no ye declare wie electoral commission wo say ade e duress wo electoral commission wo say de court to court nim etre court say yama declaration na yama no under duress nenkeni kwansi e declare ma NDC for no enti court bo declaration ni gu but no insisa NDC mom na de court na NDC kra de court no hwe de judge no kokoye Inti lawyer ni nsemu a woka no se nanka isi ni mom ene wo se court. Also yesterday's proceedings were flawed. The other interested persons were not made parties to the process. This was a clear breach of natural justice. Into the other interested persons, send ya no to say MPP, any other parties no. Or more case ni can say yan form one can. Meanwhile, they are the stakeholders. Also, the private legal practitioner also stated that the judgment of the court was premature. The judgment na court ne ma ekran na nka ni kwan say ye ma judgment sambre no. He pointed out issues of timing, stating that Order 55, Rule 53 of CI 47 gives a respondent to an application for judicial review a settled time period of not less than 7 days to respond. This application was filed on 17th of December 2024 and heard on the 20th. That was extremely curious. The Emrakra Trese case be say ba at least 7 days. But some ba 3 days na judge no e the ruling aba. Workers away there in try this is a private legal practitioner who has exposed the judge who ruled for recollation against the NDC. Montreal, your comment box, me that's it.